Good day. My name is Richard Susskind. I'm recording this from England. I live just outside London. I'm so sorry not to be able to be with you in person at your conference, which seems to me to be a vital event. My specialty over the last almost 40 years has been the use of technology in the practice of law and the administration of justice. And for a few minutes, I'd like to talk to you about my recent work on online courts. I've been working in this over the last 5 years or so, and I have a book called The Online Courts and the Future of Justice coming out next month. Just in the few minutes available to me, I want to say a little bit about the problem I think we're trying to resolve in today's court systems around the world. I'd like to talk about the mindset you might usefully have as senior judges in thinking about the future. I'll introduce the idea of online courts as well in two parts. One, looking at what I call the first generation of online courts, and secondly, looking at the second generation of online courts. As for the mindset you might usefully have, you should distinguish in thinking about technology between automation and transformation. Automation is using technology to streamline, improve, and optimize our old ways of working. Transformation in technology is to use the power of technology to allow us to do things that previously weren't possible. So we should be thinking not just of computerizing our own old justice system, but the ways that we can use technology to allow us to meet people's needs in new ways. So what are these needs? I was asked some time ago to give a talk to neurosurgeons, and I was invited to be controversial. And I said to them that patients don't want neurosurgeons, forgive me, patients want health. And I say of the same of courts. I don't think that clients, litigants necessarily want courts in the way they operate today. They want their disputes resolved, often speedily and at lower cost. And they want their problem heard, or they want their dispute, as it were, to disappear. So we shouldn't assume that the only way of delivering litigants the outcomes they require is by using the current court system. So let's think ahead and combine this idea of transforming and focusing on the ultimate needs of users of court system and think about online courts. The question I think we need to ask in this context is court a service or a place? Is court a service or a place? We always assume you need to assemble in a physical place to resolve your differences. But is that so? Do we really need to confront each other for all disputes? And my concern often is with low value disputes, the large volumes of low value disputes that so many justice systems find hard to manage. For all of these, do we need to assemble and have oral hearings in a physical courtroom before a human judge? Or might there be different ways of resolving these disputes? So this takes me to the idea of online courts and to the first generation. So what problem are we trying to resolve? According to the OECD, only 46% of people live under the protection of the law in our world. Only 46% of people have realistic access to legal advice and to judges. More than that, in some jurisdictions, and I'm afraid Brazil is one, there are staggering backlogs in these systems. Apparently, in Brazil, there's a backlog of 100 million cases in your court system. In India, there are 30 million cases in the backlog. This means that justice is not being delivered to many people who have justiciable rights. But even in the most advanced court systems that hold themselves out as the best around the world, most civil disputes cost too much, they take too long, the process is not understandable to non-lawyers, and somehow the court system is emerging as out of step in the digital society. So that leads me to wonder, might there be different ways of resolving disputes? I was first invited to consider this in 2014, when the Master of the Rolls, our top civil judge in England and Wales, Lord Dyson, asked me to put together a team to look at online dispute resolution for low-value civil cases. And we recommended there the introduction of online courts to the English justice system. And that is now government and judicial policy in England and Wales. More recently, as I'd mentioned, I've written a full book on this subject, which lays out a standard architecture for these systems, explains why they're needed, puts them in the context of standard principles of justice, addresses a whole bundle of objections that people might have to these systems, and then looks to the future. But fundamental to the idea of online courts, in my view, is two concepts: online judging and extended courts. Online judging in the first generation of online courts is still human judges deciding cases, but doing so on the basis of papers alone, on the basis of arguments and evidence submitted to them electronically, and on the basis of responses to the parties through some kind of online platform. So it's still human judges, but no oral hearing. The process is conducted online. The second idea is of extended courts. We're now able to offer parties more help than in the past, and this may be seen to be constitutionally inappropriate. But many people, most people in fact, cannot afford legal guidance. So we can use technology to provide them with help in understanding their entitlements, in appreciating the options available to them, in helping them formulate their arguments, and in helping them interact with the judges. This is all possible through now what I call extended courts. And more, we can bring some forms of ADR within the court system, but done online. So we can have facilitators or case officers looking at cases before they go before judges online and helping out perhaps where there's simple ways of resolving them. So two components to the online court: online judging, where human judges decide decisions across a technology platform, and extended courts, where our court system offers additional services. That's the vision, and for low-value disputes, it's a simplified court service, using online courts as an integral part of the service, making it affordable, quicker, intelligible, enabling non-lawyers to conduct their own cases, providing them with tools to assess and formulate their claims, submitting evidence and arguments online, cases handled in the first instance by case officers, and then communication with judges not by oral argument, but through an online platform. Here then is a shift from the presumption that all disputes before the courts should be held in a physical space to the reverse. I believe in the future, by default, cases will be conducted online unless there are compelling reasons to assemble in a physical courtroom. The benefits are obvious. Fewer cases will reach judges. Those that do will cost less, far lower in the long run physical state, and there'll be increased access to justice. So for litigants today, or tomorrow using online courts, here we'll have a route to resolution where today many have none. And even today, people who use legal advisors, for them this may be a more convenient, less costly, speedier, more understandable service. And also for self-represented litigants today, people who have no legal advice, it seems to me that such a system would be greatly preferable. This is not science fiction. We're seeing such systems in England and Wales, British Columbia. We're seeing them in China, Singapore, Australia, and the United States. The 2020s will be the decade of online courts. Judges without courtrooms, justice without lawyers. It's a very different world. And there are all sorts of objections that I address in the book I've written, from whether or not this will be a fair trial to whether or not these systems are sufficiently transparent. And ultimately, are these systems actually capable of being developed? Now, many people criticize these systems on the grounds of justice. They say that justice will be denied because it's a different kind of court service. I argue the reverse. I think in the name of justice, critics are missing the opportunity to reduce injustice. Critics in the main are lawyers who fail to look at the system through the eyes of users. Users need a more accessible, a less costly, a quicker system, and online courts might provide this. In the second generation, which is another story for another day, we can address the question of artificial intelligence. This is some years away yet. I wrote my PhD in artificial intelligence and law in Oxford in the 1980s, so it's one of my specialties. I can confirm for you today that machines are nowhere near working and operating like judges, that systems can't yet deliver decisions with reasons as judges do, but we can anticipate a day when systems can anticipate the outcome of courts and perhaps through these kind of prediction machines, we can have some kind of determinations delivered through prediction. But as I say, that's a question for another day. But it is a question that jurisdictions that have huge backlogs should be addressing today. More people now are active users of the internet, 53%, than have access to justice, 46%. This gives us globally a new platform to offer support to those who have no realistic access to justice nor protection under the law. Remember, people don't want courts. People want the outcome that courts bring. And if we can bring these outcomes in new ways, ways that are more accessible and more affordable, we can expect that this will be a fundamental development in the future of legal services. I wish you well for the conference, and I hope we meet personally.